All right, veuillez vous lever. Please be seated.
Thank you. The appeals chamber will now hear Mr. Mladic's response. Counsel for Mr. Mladic, you have 30 minutes.
Your Honor, my colleague, Ms. Peter Louise Bagot, will be presenting on our behalf. Thank you.
Madam Presiding Judge, Your Honours, I will be responding on behalf of Mr. Mladic to the prosecution's appeal against the trial chamber's acquittal on count 1, genocide in the municipalities. As set out in paragraph 4 of the written response, nothing in the written response or the oral submissions should be taken as an admission or concession for the purpose of Mr. Mladic's appeal against his convictions and sentence. As the appellant in this matter, the prosecution bear the burden to show that the trial chamber erred in law or that no reasonable trier of fact could have reached the same factual conclusions. As the prosecution seeks to appeal an acquittal, it must prove all reasonable doubt had been eliminated at trial such that the trial chamber fell into error. It must satisfy this chamber that the evidence was so unambiguous that a reasonable trial chamber was obliged to make the inferences it now asks you to draw. The respondent submits that the prosecution fails to meet the appellate standard and demonstrate that the trial chamber fell into discernible error in relation to its findings on, first, its approach to the evidence on the substantiality of each of the count 1 municipalities, and second, its finding that Mr. Mladic and other JCE members did not possess destructive intent. The respondent asserts that the prosecution fails to discharge its burden to prove all reasonable doubt had been eliminated at trial. The respondent invites the chamber to dismiss the prosecution's appeal in its totality and uphold and affirm Mr. Mladic's acquittal on count 1. It is recalled that the written response was detailed and comprehensively covered the prosecution's submissions. My learned friend today rehearses those. For that reason, my submissions will focus on the core elements of the prosecution's appeal and will not rehearse what is already in writing. Ground 1A, substantiality of each of the count 1 municipalities. Size. The respondent refers the chamber to paragraphs 48 to 58 of its written response. The respondent asserts the trial chamber reasonably concluded that the numerical size of the Bosnian Muslim community in each of the count 1 municipalities was not substantial. The prosecution disagrees with the conclusion made by the trial chamber that it was not substantial. It does so without showing how the trial chamber's conclusions were incorrect or unreasonable. To start with the relevant jurisprudence is important. Where a conviction for genocide relies on the intent to destroy a protected group in part, the part must be a substantial part of that group. The targeted part, quote, must be significant enough to have an impact on the group as a whole, close quote. Kirstich, paragraph 8. The trial chamber methodically worked through the issue of substantiality with regard for the applicable law and with a careful consideration of the evidence. Judgment, paragraphs 3526 to 3534. The prosecution, in its appeal and today, repeats failed trial arguments. It expressly, the trial chamber, considered the physical perpetrator's area of activity and control and found that they had, quote, limited geographical control or authority to carry out activities, close quote, paragraph 3535. Further, quote, that the Bosnian Muslims targeted in each individual municipality formed a relatively small part of the Bosnian Muslim population in the Bosnian Serb claimed territory or in BIH as a whole, close quote, paragraph 3535. While the prosecution asserts the trial chamber erred in making these findings, they fail to articulate the basis of that error. In fact, they merely repeat their arguments about the size of the municipalities and compare this finding to the size of Srebrenica. This comparison alone does not demonstrate an error and fails to address the elemental requirements of the crime. The trial chamber's finding that they were not substantial in size was reasonable, and the prosecution has failed to demonstrate that no reasonable trier of fact could have reached the same factual findings. Prominence and emblematic nature. The respondent refers the chamber to paragraphs 59 and 81 of its response. The trial chamber found that the prosecution had presented, quote, insufficient evidence indicating why the Bosnian Muslims in each of the Count 1 municipalities had a specific significance or were emblematic in relation to the protected group as a whole, close quote, paragraph 3535. The prosecution argues that the trial chamber's, quote, predicate findings and the underlying evidence demonstrate to the contrary, close quote, paragraph 11. However, again, the prosecution repeats its arguments at trial without demonstrating an error in the trial chamber's approach. For example, the evidence the prosecution cites to support the assertion that the Count 1 communities were prominent and emblematic in nature are those used at trial, and the evidence is the same as cited on appeal. See, for example, the prosecution's final trial brief at paragraphs 387, 388, 389, and compare with the appeal brief at paragraph 13. This evidence...
Ms. Bagot, could you kindly pause? We've lost Judge Khan. Madam Presiding Judge, we are good to go, and Judge Khan has now been reconnected. Thank you.
May proceed.
This evidence was considered by the trial chamber, judgment paragraphs 3530, 3534, 3553, 3554, when reaching their conclusions. Further, the prosecution repeats the point that the municipalities held immense strategic importance for the Bosnian Serb leadership. Prosecution final trial brief, paragraph 386, appeal brief, paragraph 14. Again, this was considered by the trial chamber, paragraphs 35-34, when reaching their conclusions. In addition, the point that any conduct represented early steps in the Bosnian Serb campaign towards an ethnically homogeneous state was made at trial. Prosecution final trial brief, paragraph 390 to 392. Again, this was considered by the trial chamber. The respondent submits that the prosecution is repeating failed trial arguments without identifying any error in the trial chamber's approach. The prosecution simply disagrees with the findings. An appeal is not a de novo trial. The appellate standard is not met simply because the prosecution want a different outcome. Therefore, save for comparing the findings in relation to Srebrenica at paragraphs 11, 12, and 14, the prosecution fails to explain why no reasonable trier of fact, based on the evidence, could reach the same conclusion as the trial chamber did. The respondent asserts that the prosecution fails to demonstrate that the findings of the trial chamber were incorrect or unreasonable in relation to the Count 1 municipalities. For this reason, Ground 1 should be dismissed. Ground 2. The prosecution fails to discern an error in the trial chamber's finding that Mr. Mladic and other JCE members did not possess destructive intent. The respondent submits that the prosecution fails to meet the high standard on appeal and eliminate all reasonable doubt, such that this chamber could overturn the trial chamber's findings that he did not possess destructive intent. Ground 2A. The respondent asserts that the trial chamber did not apply a heightened evidentiary threshold when assessing the destructive intent of Mr. Mladic and the OJCE members. The respondent refers the chamber to paragraphs 88 and 143 of the response. The jurisprudence makes it clear that, quote, it is the genocidal intent of the accused and other alleged JCE members, not the physical perpetrators of the underlying genocidal acts, that is determinative for the purpose of JCE 1. Karadzic, 98 bis appeals decision, paragraph 79. The trial chamber expressly considered the prosecution's arguments, which it repeats on appeal, that, quote, the number and nature of the crimes considered together reflected an intent to destroy the group in part rather than an intention to ethnically cleanse, close quote. That can be seen in the judgment at paragraph 4235. Again, the trial chamber worked through the evidence presented by the prosecution carefully and applied the correct legal standard. The prosecution fails to show an error in the trial chamber's conclusion that, quote, in the absence of other evidence which would unambiguously support a finding of genocidal intent, drawing an inference on the basis of prohibited acts of the physical perpetrators alone is insufficient. Paragraph 13-56-A. The prosecution fails to show that the trial chamber applied a heightened standard in this regard. In the Stakic appeals decision, the appeals chamber recalled, quote, "A trial chamber may only find an accused guilty of a crime if the prosecution has proved each element of that crime, as defined with respect to the mode of liability, beyond a reasonable doubt."
Ms. Beckett, could you kindly pause? Thank you. Madam Presiding Judge, we're ready to proceed. Thank you.
Please proceed.
Continuing the quote, "This standard applies whether the evidence evaluated is direct or circumstantial. Where the challenge on appeal is to an inference drawn to establish a fact on which the conviction relies, the standard is only satisfied if the inference drawn was the only reasonable one that could have been drawn from the evidence presented. In such instances, the question for the appeals chamber is whether it was reasonable for the trial chamber to exclude or ignore other inferences that led to the conclusion that an element of that crime was not proven." End quote. The respondent submits the trial chamber did not apply a heightened standard. The trial chamber applied the correct standard in accordance with the jurisprudence and the applicable law. The approach the trial chamber took was to apply this law to separate bodies of evidence relating to the physical perpetrators and then separately Mr. Mladic and the OJCE members. The respondent submits that the prosecution fails to demonstrate an error in this regard. The trial chamber specifically and explicitly applied the standard to the evidence and found that the prosecution's reliance on the use of a number of physical perpetrators as tools was insufficient. The prosecution failed to discharge its burden of proof because it failed to demonstrate that the genocidal intent was the only reasonable inference that could be drawn from the evidence. Its complaint on appeal does not demonstrate an error in the trial chamber's findings, nor evidence the application of a heightened standard. Further, it fails to show an error in the trial chamber's finding that genocide did not form part of the common purpose or the OJCE. The trial chamber's findings was based on an assessment of, quote, the entire trial record, close quote, but still could not be satisfied that, quote, the only reasonable inference that could be drawn from the evidence, close quote, was that genocide formed part of the objective of the OJCE, paragraph 4273. The trial chamber carefully considered the evidence, as that reference to the judgment shows. Again, it is not enough for the prosecution to say it wanted a different outcome. It has to demonstrate an error or prove that all reasonable doubt had been eliminated. My learned friend repeats the failed submissions at trial. The prosecution fails to meet the appellate standard and show how the trial chamber applied a heightened one. As such, there is no reason for the chamber to intervene. (2)(b). The prosecution fails to discern any error in the trial chamber's findings. The respondent refers the chamber to paragraphs 144 and 187 of the response. Given the prosecution's submissions made in this regard, it bears repeating what the appeals chamber found in the Karadzic 98-bis decision. It is the genocidal intent of the accused and the other alleged JCE members, not the physical perpetrators of the underlying genocidal acts, that is determinative for the purpose of JCE 1. The trial chamber applied the correct legal standard when it considered the evidence. It considered whether or not the only reasonable inference that could be drawn was the one the prosecution invited. It weighed the prosecution's evidence and found it wanting. The prosecution fails to discern any error in its approach. It fails to show on appeal that the evidence was so unambiguous that a reasonable trial chamber was obliged to infer that all reasonable doubt had been eliminated. On appeal, the prosecution simply disagrees with the outcome. For this reason, the respondent submits that ground 2 should be dismissed. To conclude, the respondent refers the chamber to paragraphs 190 and 343 of the response. The respondent invites the chamber to dismiss the prosecution's appeal, reject the remedies sought, and affirm and uphold Mr. Mladic's acquittal on count 1. Finally, Madam Presiding Judge, Your Honours, I wish to address the court and the chamber on JCE 3. The respondent invites the chamber to revisit Mladic. Whether or not the notion of JCE 3 has a legal basis in customary international law is of general significance to the tribunal, not only for legal certainty, but also for the tribunal's legacy. Concerns about the legal basis of JCE 3 have been consistently raised in separate and dissenting opinions by judges at this tribunal, as well as in academic commentary. Furthermore, the ECCC has distanced itself from it. The ICC has distanced itself from it. A wholesale review of the jurisprudence relied on in Mladic to support its findings that JCE 3 had a basis in customary international law has never been undertaken at this tribunal since 1999, when the decision was rendered. It is recalled that unofficial translations of the Italian cases were relied on by the appeals chamber. Official translations have never been obtained by this tribunal. The legal foundations of JCE 3 have in many ways been shrouded in secrecy. The prosecution argues that the respondent's challenge to JCE3 is much the same as those previously made, and therefore should be dismissed. It is not. No other submission arguing that there are cogent reasons to depart from Tadic has provided a comprehensive analysis of all the relevant jurisprudence in this regard. No other submission arguing cogent reasons has ever gone through each and every case, not just the summary provided in Tadic, and explained at length why there is no support for the suggestion that a form of JCE3 was applied in each. And no other submission arguing cogent reasons has ever found and translated the Italian cases into a language of this court. The respondent's submissions do not just say, overturn JCE3. They step the chamber through why the legal basis of JCE3, as articulated in Tadic, cannot withstand scrutiny. For the first time in over 20 years, the respondent has placed before this chamber everything that the Tadic Appeals Chamber relied on, and translated it to demonstrate that liability for crimes not encompassed by the common purpose did not exist in customary international law at the relevant time of the indictment. This chamber has the opportunity to consider the foundations of JCE3 from scratch. JCE3 has proved to be controversial during the life cycle of this tribunal. This is the last opportunity for the appeals chamber to confront it head-on. Genocide is a specific intent crime. JCE3 enables an accused to be held criminally responsible for genocide on the basis of foresight. As the standard of mens rea is lowered, JCE3 has often been dubbed the prosecution's darling, as it has been used as a legal loophole to facilitate convictions for genocide without the need to prove a specific intent. The respondent submits that after a careful analysis of the case law, the very foundations on which JCE3 was built in Tadic are called into question. The prosecution in reply states JCE3 is, quote, established law, and relies on the fact that other chambers have followed suit to argue that this chamber should, in effect, leave the matter alone. In our submission, if the law has taken a wrong turn, then this chamber must correct it. The respondent implores the chamber to do what no one has done since 1999, review the legal basis that the Tadic Appeals Chamber alleged supported the notion of JCE3. What we invite this chamber to do is go where no other appeals chamber has, back to the beginning. In the absence of a solid legal basis showing consistent and virtually uniform state practice, showing that liabilities for crimes not encompassed by common purpose existed in customary international law at the relevant time of the indictment, JCE3 cannot stand up to scrutiny. It has been weighed, it has been measured, and it has been found wanting. Madam Presiding Judge, Your Honours, time is up for JCE3.
I missed the I missed the last submission. There was a lot of background noise. Counsel, can you please repeat? Are you done?
Sorry, Madam Presiding Judge, I didn't see the transcript. Yes, I am.
You have concluded your submissions?
I have, yes.
Thank you very much. The appeals chamber will now hear the prosecution's reply. Counsel, you have 15 minutes.
Thank you, Madam Presiding Judge. Your Honors, I'm going to start where my learned colleague left off with joint criminal enterprise. The Appeals Chamber has consistently found that joint criminal enterprise 3 is a form of liability under customary international law, including for specific intent crimes. And this is not the Appeals Chamber's first chance or the chance to resolve the matter once and for all. This matter has been resolved repeatedly, again and again over the last 20 years, most recently in the Karadzic and Perlich appeals. The Tadic Appeals Chamber properly analyzed the World War II era cases to find that JCE, including JCE3, existed as a form of liability under customary international law. And the Appeals Chamber has repeatedly confirmed that JCE is firmly established in custom. Mladic claims that the Italian materials are new because he offers translations. But all of the arguments he makes on these translations have been considered before, not just in Tadic, but also in the Burjanin and Karadzic appeals. Your Honors, if any documentary source is really new in this case, it's the U.S. Forces Manual for the Trial of War Crimes, which further confirms that a JCE3 concept was applied by post-World War II courts. And this document is found in our Book of Authorities and referred to at paragraph 46 of our reply brief. And since Tadic expressly declined to rely on national systems as a source of law, since they were too diverse, these national cases have no impact on the reasoning in Tadic. The jurisprudence is also long settled with regards to the application of JCE3 to specific intent crimes. The Burjanin Appeals Chamber unanimously held that a conviction for genocide can be entered on the basis of JCE3. And the Appeals Chamber has reaffirmed that JCE3 applies to genocide in Stakic and in Ramakuba, and to the specific intent crimes of torture and persecution in Stanisic and Juplinin and Georgievich. There is also nothing new in Mladic's attempts to invoke non-binding decisions from other international courts, such as the ECCC. Again, the Appeals Chamber has repeatedly confirmed that these decisions did not demonstrate any mistake in the ICTY's approach. And I would refer you, for example, to the Perlich Appeals Judgment, paragraph 590. The argument that the application of JCE violates the principle of null and crimen sine lege has been consistently rejected by the Appeals Chamber. Mladic has given this chamber no cogent reasons to overturn 2 decades of consistent jurisprudence, and this argument should be dismissed. Turning back to my learned colleague's submissions on ground 1 of our appeal. Your Honors, it's the numbers that really demonstrate the error. The outcome of the trial chamber's analysis is unreasonable in and of itself. The question of substantiality is sometimes framed as asking whether the destruction of the part would have an impact on the group as a whole. Kerstich Appeals Judgment, paragraph 8. But this impact formulation cannot require the intention to destroy the group as a whole, because setting the bar that high would make the impart language meaningless. And the destruction of a part of a group measured in the tens of thousands is a crime of massive proportions. The destruction of any of the Bosnian Muslim communities of entire municipalities forming distinct parts of the Bosnian Muslim group would necessarily impact the Bosnian Muslim group as a whole. And when you, Your Honors, when you add the two distinct parts of the group that were targeted by Mladic's subordinate Basara, when you add those two groups together, Insanski, Most, and Prijedor, based on the Chamber's own findings, that is 80,000 people, a group of 80,000 group members. Your Honors, I'm pausing for a moment just to give counsel a chance to consult with his client.
Apologies, Your Honor. There was a problem with Mr. Mladic's screen. We have resolved it.
If I may continue. When you look at when you look at the two distinct parts of the group which were targeted by Basara, and you have 80,000 group members, why is this not substantial? The trial chamber never looked at those two parts together, even though it found that Basara intended to destroy both parts of the Bosnian Muslim group. And when you consider all 5 municipalities together for the JCE members' intent, it is simply impossible to imagine that the loss of a part of the group comprising over 128,000 members would not have an indelible impact on its whole. And that is why, on the numbers, that the prosecution says that this was an unreasonable finding by the trial chamber. Turning to ground 2 of the prosecution's appeal. Your Honor, in ground 2, we have alleged both a factual and a legal error. And the legal error that I focused on today is that the trial chamber applied the wrong legal test. And they exhibited that when they said that the circumstantial evidence of the pattern of crimes of the principal perpetrators under the control of the JCE members was insufficient. That for the JCE members, for the leadership, they required more. And once the prosecution has shown a legal error, if the appeals chamber agrees that there's a legal error arising from the application of the incorrect legal standard, then it is for the appeals chamber to articulate the correct legal standard and review the relevant factual findings of the trial chamber accordingly. And I refer you to the standard of review on appeal as set out, for example, in paragraph 16 of the Karadzic appeals judgment. Your Honors, in the break, I had a moment to consult with my Karadzic appeals judgment so that I could better answer Judge Nahamia's question from before the break. And I just wanted to confirm the two distinctive factors between the Karadzic case and this case. In this case, the genocidal acts of killing, extermination, cruel and inhumane treatment amounting to serious bodily and mental harm, those are found by the trial chamber to be within the common purpose of the joint criminal enterprise. Whereas in the Karadzic case, only the forcible transfer, deportation, unlawful detention, and restrictive measures were part of the common purpose. So we have a distinction in the nature of the crimes that were inside the common criminal purpose. And the second point is that in this case, many of the local perpetrators were found to have destructive intent. And as I've explained, the trial chamber only fell short of calling this genocide because it found that the part they targeted was not substantial enough, not big enough. But as I explained in my submissions, this holding is erroneous on the sheer numbers alone. In the Karadzic case, nobody was found to have the intent to destroy the group in whole or in part. And to go back to the second question on the Karadzic indictment, I have confirmed that 4 of the 5 municipalities are the same. The Karadzic indictment had a larger list, as did our case originally, but Kotorvaros was not in the Karadzic list. It had been removed. So 4 of the 5 municipalities are the same. Your Honors, to conclude, this is a case that calls for appellate intervention to reverse Mladic's acquittal for count 1 genocide in the municipalities. If Your Honors do nothing, the risk is that the Mladic case will stand for 2 dangerous precedents. First, that targeting 128,000 people is not enough to be considered genocide. And second, that senior officials enjoy a different legal standard than principal perpetrators. Both of these propositions are wrong in law. And if left uncorrected, this will be the legacy of the ICTY and the mechanism. Your Honors, it is in your hands to correct these errors. And it is in your hands to shape the world's understanding of these historic crimes. And it is in your hands to convict Mladic for his role in the 1992 genocide of the Bosnian
Could you
Muslims
kindly pause
in the
a-
municipalities.
Ms. Begg?
I can.
Thank you. Madam Presiding Judge, can you hear and see us now?
Yes. Prosecution counsel, have you concluded or we are still going on?
Madam Presiding Judge, I finished and the conclusion is in the record on the transcript. I'm happy to say my final words again if that would assist you, but it is in the transcript.
Very well. The last item on the agenda of our hearing today is the optional personal statement of Mr. Mladic, should he wish to make one. Mr. Mladic, would you like to make a personal statement not longer than 10 minutes?
Your Honor, my client has indicated that he does wish to make a statement. Before he does so, I have to give a precautionary information, as is my ethical duty, to remind everyone that Mr. Mladic is a man who suffers from several medical ailments and conditions. I do not know what medications he regularly takes or took this morning. I do know he was scheduled to take medication at 6 in the evening, but due to our schedule and sitting here now 2 days in a row with this schedule, the packet for the 6 o'clock medication was not sent here and he has not taken that medication. Further, I have been unable to render assistance for him to prepare meaningfully for this address to the chamber. I have reasonable suspicions as to his capacity, as I've set forth before, and therefore I would only, I have doubts as to his understanding of the consequences of these proceedings and his statements, but I would ask you to keep in mind his medical condition and his potential incapacitated state and how that may affect, how that illness may affect his speech. But since the majority decision has ruled as it has, I have to abide by my client's wish to give and allow him the opportunity to speak if he so wishes, and so therefore I defer to Mr. Mladic on this matter. Thank you.
Thank you, Mr. Mladic. Would you like to make a personal statement? Are you in a position to do so?
Poštovana predsjedavajuća.
Distinguished presiding judge, with all my troubles and worries, health-wise and otherwise, I do have the wish and intent to address you. But I would kindly ask you not to limit me to 10 minutes, but at least 30 minutes, because since the 16th of June, 1992, I had been pushed into war, and for every minute of that war I have something to say, not for my own sake or for the sake of my own, but in the name of our people and the huge number of my associates and collaborators and the Serbian people who have been in the crosswinds of the Balkans ever since. It is through the Balkans that all the crusades, all the insurgencies, all the wars with Ottoman Turks, with the Austrian Empire, with Hitler, have gone on. And the same applies to this imperialistic period. I would like to have my say, if you allow me, about all that. With your leave, and I would appreciate it very much if you give me that leave, I would take 31 minutes. off the top of my head, because I am an eyewitness to all the undesired and unfortunate events during the war. I was and still am a target of the NATO alliance, and please don't take offense if I say that this tribunal, of which I have a very, very low opinion, is a child of the Western powers that have been blowing the same horn ever since the fall of the Berlin Wall. Despite the fact that the President of the United States has said, lying, that the NATO alliance would not spread its borders up to Russia. So who is the real representative of the United States? The President or this blonde lady who has been showering me with satanic, snaky, devilish words? I am none of the things that you called me. Please let me have my chance to reply to the lady who has either swallowed a snake or the NATO indictment against me. It is no use trying to wash this child of the NATO alliance clean. That is all for now, but I have much to say in continuation if you give me permission.
And some of it is already gone, so you better be sticking to few points by the end of the 10 minutes. You may proceed.
Sada sam u poziciji
I am now in a position to defend not myself, because I'm not defending myself. I am a man who has been a professional soldier all his life. I worked in peacetime and in war in accordance with the laws of my country that was destroyed by the NATO alliance. Is Ratko Mladić to blame? Because he didn't allow the Ustasha enemy to throw Serbian children into pits like they did during the Second World War. Was the trial chamber who sentenced me to life imprisonment correct? No, they're not. They're wrong. And why are they wrong? Because they have a conflict of interest. They were defending not the truth. They were defending the Netherlands and the Dutch bat. I was in Srebrenica, unlike all of you here. During my time, from 9 July until the 13th of July, when I signed the Krivaja document in Vlasenica, an error was made there when it was dated 12th of July. I was followed by cameras throughout Srebrenica. I was shot at by some straggler of the 28th Light Muslim Division of the BH Army, and he missed me, although he was firing at short range. I was holding a heckler at the time, and I said, "Stop shooting." He had missed me once already. I didn't even try to shoot back. I didn't even allow my security men to shoot him, because he was wearing a vest of the United Nations.
Thank you.
Izvinjavam se.
Apologize.
Madam Presiding Judge, we're ready to proceed. Thank you.
Mr. Mladic, you may
Hvala.
continue.
Hvala lepo.
Thank you very much. Srebrenica is the key to this trial. And what is Srebrenica? Historically speaking, it was a town of the Nemanjić kingdom where lead and gold were mined. Dragutin Nemanjić, at the time of the Tsars, founded many monasteries there. But over time, things happened as they happened. As far as I know, in the time of the Socialist Federal Republic of Yugoslavia, there were no paramilitaries. They didn't exist. The army did not have a presence there. And as an officer, I had never been to Srebrenica before this last war. I've never been to Žepa or Gorazde. I'm asking all of you, and I'm asking myself. In 1993, I believe it was towards the end of May, UN protected areas were established in Sarajevo, in Bihać, in Srebrenica, Žepa, and in Gorazde. As that Frenchman would say. And that's fine. At that time, I signed with Halilović, commander of the BH Army, an agreement to honor these UNPAs. And that meant that Srebrenica was supposed to be demilitarized, including an area of 3 kilometers around it. Žepa, Gorazde, Bihać, and Sarajevo were to be demilitarized as well. The war continued in Sarajevo, and after 1993, the First Corps of the BH Army stayed there. Were they disarmed? No. And who's to blame? Ratko Mladić. Generals Morion, Janvier, Smith, Rose took their turns and nothing happened. I am not a saint, Madam Judge. I am a simple man. I said that many times during the war. Fate put me in a position to defend my country, the SFRY, that you Western powers had devastated with the help of the Vatican and the Western Mafia, Bush and Kinkel. Ratko Mladić was not the one who started that war. He was not the one who made the plan to attack Yugoslavia.
I thank you for your statement.
Žao mi je
And I
što me
now-
prekidate.
I'm very sorry that you have interrupted me. My time is only just coming. People will hear what Ratko Mladić has to say. I am alive and I will live as long as our tribe and our people live. Thank you. And this indictment of yours has gone down the drain.
Thank you, Mr. Mladić. Is there anything further from the parties before we conclude?
Not from the prosecution. Thank you, Madam Presiding Judge.
Thank you. Defense, anything more?
Nothing for the defense except to again make reference to my reservation of rights, objection, and everything that I said yesterday and today in that regard. Thank you.
Thank you. This concludes the hearing of the appeals in this case. Before we adjourn, I would like to take this opportunity to thank the parties, both parties, for their hard work in this case. Additionally, I would like to express my gratitude to all staff at the Hague branch for facilitating our hearing today and yesterday during this challenging time. I would like to also thank the interpreters for their excellent assistance. And I would like to especially thank IT department at the Hague branch for assistance rendered to me at this remote location to be able to participate in the appeals hearing, without which that would not have been possible. The appeals chamber will render its judgment in due course. We are now adjourned.